It is well known in the well-known judgment. That is what he's saying.
Well, I am not disputing that. If your lordships, well, I think that by now your lordships have just sufficient experience to read and understand what it means. And what it means is that you don't please proceed further in the matter. It's obvious. It's so obvious. I don't have to elaborate it.
Nabam, the correctness of Nabam would arise if the speaker stood injuncted either by the High Court or by this court from exercising his powers under the 10th schedule. If the speaker was injuncted from exercising his powers under the 10th schedule until the vote for his removal was taken up.
Right.
Or he himself says that, look, in view of Nabam, I'm not going to exercise my jurisdiction.
Right.
Then somebody else may say that, well, you have to exercise that jurisdiction. Now, in our case, what happens is that when the speaker perhaps in that sense created a problem for himself, maybe out of the political exigency. We're not at all saying that in a pejorative sense. That's real politics. The speaker himself gave only 2 days notice. 25th, he said, I'm going to give you time until the 27th. Our court, in the light of that, said that time to furnish your reply is extended until the 12th of July.
In the interim, your lordship may not have looked at that phrase.
Yeah, in the interim.
In the interim,
Now,
it is extended.
A trust vote takes place.
Yes.
The then government decides not to face the assembly, it resigns.
Right.
Therefore, what impact the vote or non-vote of these people who were sought to be disqualified by the speaker would have was never tested on the floor of the House.
Only on the 4th it was tested.
The resignation.
The 4th it was tested.
No.
Yes.
On the resignation of the Chief Minister obviated a reference, obviated the floor test.
No,
Therefore,
it happened on the 4th.
On the 30th itself.
Before Shinde, it happened. The same thing.
No, but on the 30th, what happens is this. On the 30th, when the floor test is to take place, the government resigns on the 29th.
Right.
The moment, of course, they got to know that the floor test is going to be held and there is no stay by the Supreme Court. Now, as a result of that, what happens is that the consequence of the vote which would otherwise have been cast by a person who was sought to be disqualified on the overall voting pattern never emerges before the assembly. So in which case does the correctness of Nabam Rebia fall for consideration?
Yes, Manoj, I will demonstrate that immediately.
And should we go into the validity of Nabam Rebia merely because obviously very interesting constitutional issues arise, because when we decide a constitutional issue in the absence of a factual background, it's clear that the court is trenching upon something without full facts.
Kindly then look at the notice, Manoj. Twice it has happened. On the 3rd they voted, on the 4th they voted. 3rd they elected a speaker. 4th, Manoj, the trust. Define our whip. Because Manoj, the whip had not been changed by them. That was changed. Gogagare came in on the 3rd night, Manoj. So all that is before you now. But be that as may, let me answer a more fundamental question. Let's kindly look at the notice of the 22nd of June that my learned friends have been relying upon. Convenience compilation, volume 2, PDF page 62.
22nd June. 22nd
June, but dated 21st of June. Yeah, I know.
Convenience compilation 1, right, Mr.
Yeah, 2, compilation 2, Madam. It's a very interesting document.
Page number,
PDF 62, otherwise 49. Just mark one date, Madam, in your mind before we read this document. 23rd of June, petitions are filed for disqualification.
Once more, that date is?
23rd of June,
yes.
Petitions are filed for disqualification. 25th of June, Speaker issues notice for 27th June. These 3 dates.
Correct.
Give me just a moment.
Will you please repeat yourself, Mr. Sibal? 23rd June, petition filed
For disqualification of the 16th. 25th of June, Deputy Speaker issues notice. There is no Speaker. For 27th.
Correct.
27th, this court passes that order. Now, let's kindly read this notice of dated 21st June. And if your lordships has the document, and kindly see on the left-hand side, 22nd June, 2022, 11:33. So it is received by the Deputy Speaker on the 22nd, but dated the 21st. Obviously, Malaj, they have.
Yes, it is received on the 22nd.
Yes. It's received on the 22nd, it is 11:33. Now, Malaj, the last session of the Assembly, which was the budget session, took place from the 3rd of March to the 25th of March, 2022. Now you see the mischief, Malaj, when we did 3rd of March to 25th of March, 2022. Now see the mischief, Malaj. Just read this note. You were elected as Deputy Speaker of the Maharashtra Legislative Assembly on November 19. Since February 21, due to resignation of Nana Patole from the post of Speaker, you have been discharging functions of Speaker of Maharashtra Assembly. We all respectfully submit that you no longer have the right to continue as Deputy Speaker, as you no longer enjoy the support of the majority of the House, and more particularly the following members of our party. In well-known judgment of the Honorable Supreme Court in Navam Rebia, it has been held that if the Speaker and or the Deputy Speaker rightfully and truly enjoys the support of the majority, there would be no difficulty whatsoever to demonstrate the confidence with which the members of the state legislature repose in him. In your case, you do not have the requisite. Further, under 179C, Speaker can be removed from his office by a resolution of the Assembly. We members of the Sena Legislative Party constitute 34 members and therefore are issuing the present notice under Rule 11 for your removal. Right, Numbers? Meanwhile, we request you to refrain from discharging your functions as Deputy Speaker with immediate effect. There was no disqualification petition. Reference to Navam Rabia, there is no disqualification petition filed. There is no notice issued. How is this academic?
A reference says that notice to move a resolution for removal. Just come to page 49.
That's correct. Correct.
Isn't this that?
On what ground?
No, that's a different matter. You are saying there is no review.
No, I'm saying then you cannot discharge your functions, he says at the end.
That's a different matter, that what he can do. But then I'm talking about the notice. You are saying there is no notice. It's actually a notice, right?
Para 5 says we are members of the Assembly, and therefore as issuing the present notice, it is notice of disqualification.
Hereby call upon you to move the motion for your removal.
That's right, and under Rule 11, and then says that you are now, therefore you can hold your hands, you cannot deal with anything. Because they know that a disqualification petition is going to be filed. Therefore they preempt it. There was no notice on that day. There was no petition on that day. And how is therefore Navam Rebia an academic exercise here? And how did they rely upon Navam Rebia?
This disqualification petition on the 23rd, right?
Yes, afterwards. Obviously, they wanted to paralyze his functioning. The whole intention.
No, Mr. Counsel, Navam Rebia is referred to for a different purpose, not with respect to disqualification. Please read para 3 of that letter.
Yes.
It is referred to for a other person.
Yes.
Other reason that in Navam Rebia it is observed that the Speaker, so far as Speaker is concerned, so and so. It is not with respect to disqualification to conclude the tense candidate. No, we are on your supposition that at that time there was no confidence.
Navam Rebia only deals with disqualification.
Now please see para 3.
I am reading paragraph 3. It is the speak.
It is well known, in the well-known judgment. That is what he is saying.
I am not disputing that. If your lordships, I think that by now your lordships have just sufficient experience to read and understand what it means. And what it means is that you don't please proceed further in the matter. It's obvious. It's so obvious. I don't have to elaborate it. Read the last line of the notice. We request you to refrain. Where is that? What is the Deputy Speaker function is also under the 10th schedule, I mean, let's not.
You're reading Navam in para context.
We understand. Let's be clear. And you can't discharge your functions as a Deputy Speaker. Means I can't discharge under the 10th schedule. So that's
Your
clear.
simple point is that there was no complaint under 10th schedule. There is the question of a notice given.
Exactly. And how is this academic? The whole purpose of it was to paralyze the Speaker. Purpose of it was to ensure that I do not deal with the disqualification petition when it comes. And they knew it was coming. In politics, there is no secret.
There was already.
What happens, at one end is known to the other person. So somebody must be drafting the petition, and they must be knowing it. Say, let's draft the letter dated 22nd, date it 21st, and send it to them. See, this is practice.
Obviously, everybody knew what was going to happen.
So, Manoj,
Who doesn't?
say that this all is
They are
academic exercise.
they are times ahead of times to come. You know?
Yeah.
It's all, who doesn't know? I mean, even citizens know about it, forget about legislators.
That's right, even citizens know. Manoj. So therefore, let's be clear, the whole initiation of the exercise,
The 10th schedule now has been internalized by the political establishment. So they knew exactly
I
what
said that in my opening, Manoj. I said that in my
it's
opening.
been internalized.
Very
Like,
sad.
they also knew exactly what's going to happen. It's like everybody is, it's like a chessboard. Everybody knows what's the next move.
No, Manoj,
Exactly.
look at it from another standpoint. I'll come to the 10th schedule later.
Yes.
Another standpoint. Manoj, under the 10th schedule now, even if the majority defects, it will still be defection. There is no concept of majority, minority under the 10th schedule anymore. The only concept is of merger.
Merger, that's the only thing. I think.
So to say that the majority, we are 40, is no defense under the 10th schedule.
But this is not a case of merger also, as
It's no, it's
Kapil is saying.
It's not their case of merger. So to say, but I've been hearing this refrain that we are 40, they are, it makes no difference. That is why para 3 was removed. These are very serious issues. You can't apply Naban Rebia in this fashion. And therefore, Manoj, my lord, put it to me, if you have lost the plot. Manoj, we have not lost the plot. Because the 10th schedule itself allows me. There is no defense available. Which is why they don't want this to go on. Which is why, Manoj, they are saying it is academic, don't deal with it. Our speaker will decide. Now we have a new speaker. Manoj, and now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, Manoj? Manoj, these are not conscientious objectors, Manoj, like in Soviet citizen wars, Manoj, in Russia.